It happened. You were charged with a crime. You did everything you possibly could to work your way through it. You went to trial and you lost. You presented your evidence. The judge heard it. The jury heard it. And they came back with a guilty verdict. It's something that I've been a part of. It's something that I've seen our clients be a part of. And it's not a fun experience. It's a devastating blow, especially when you fought so hard and you put so much energy into it and you could think that you could see some light at the end of the tunnel. Well, now what? What do you do? Many people just roll over and they say, well, that's the end of the road. Gave it my best shot. We're going to call it a day there. But there is a lot you can still do. It's through the appeal process. And today we're going to talk a lot about that. We're going to talk specifically about how to file a notice of appeal in an Arizona misdemeanor criminal case. And so if you look closely, you'll notice that it says notice of appeal, which is really the early stage of the appeal process in any criminal case. So we're going to dive through a lot of different items here. We're going to talk about why you should appeal, what some bases for appeals are, and really show you what an actual notice of appeal looks like so that if you're inclined, you can file this on your own. So as you'll notice, I said how to file a notice of appeal in an Arizona misdemeanor criminal court case, but that kind of presumes that you want to, right? And in order to decide whether or not that's a good decision, we need to answer the question, why should you appeal? Why? What's the reason? Why would people appeal their case? Well, many people come to our firm and they ask that question at the very beginning before the case has even started. Why should I hire a lawyer? Is this something that I can do on my own? Is it worth it? What are my chances? Can we beat this thing? Is there an opportunity for us to win? And those same questions come up at the end of a case during an appeal process. People want to know, what's the likelihood of me succeeding in this? Well, the long and short of it is, if you lost your case and you want to win your case, the only way for you to do that is to appeal it. You have to go through the appeal process. So if you want anything better than a 0% chance of succeeding or altering that conviction, you have to appeal it. So the real question is, why wouldn't you? There are some limitations on appeals. There are some difficulties, and we're going to dive into those. But let's think about this from the court's perspective or from the legal perspective. If you've gone through a trial and you've lost your case, if you appeal it, there are really four things that can happen. The first is the worst. The court, the appeals court, the superior court in this case, can take a look back down at what happened in your trial and say, we think everything was fine. Everything went according to plan. There's nothing to appeal here, and we're going to affirm that result, which means you're still found guilty. You're still convicted of that crime. That's obviously not what we want. But there are three other things that can happen. Let's take a look. Number one, the court can overrule the trial court. So the court can say, yeah, you found this person guilty and we're going to find this person not guilty. We're going to overturn that conviction because they reviewed the record, they reviewed the appeal, and they said that this was not good. This was not a reasonable, valid trial. And so they're going to then reverse or overturn the underlying trial court. They could also modify the trial court's sentence. So many times this is in the interest of the defendant, so the person who was convicted, they have one type of sentence or one set of penalties, and the appeals court can come back and modify that. They can say, well, the original sentence or the original rendering of that sentence was invalid, and so we're going to ask that the trial court modify that. So you can improve your situation there. Certainly you improve your situation if you're convicted and the court overturns it, but if you can't get that, then you can go through and you can say, well, the court's going to modify the sentence, and so we're going to have a better result that way. And finally, number four is the court can just say, you know what, we don't really know what happened. We don't know if this was the right outcome or the wrong outcome, or the rule was followed or not followed, or there was a problem. So we're just going to have you do the trial over again. So it's a redo. You get to go back down, and the appellate court remands the case back down to the trial court, and you get another crack at it. So you're basically rewinding the clock back a bit and having a new trial. All of those three options are pretty good, and if you're in a position where you've been convicted of a crime and you want to do something about that, the appeal is really the only way forward in most circumstances. And so that answers the question, why appeal? Why? And I hope there's some, a basis for that. If that doesn't make sense to you, you may just want to pull the ejection cord and hop out of this video. But the appeal is really the only way that you can move forward to overturn a verdict. You want to appeal that verdict. It's also important to note that there's a big difference between what's called a notice of appeal and an actual appeal. So you can see here these two different phrases are not the same. A notice of appeal is not the entire appeal. There are two separate processes. And so today what we're only going to be talking about is really the notice of appeal. We're going to touch on appeals, of course, because that's just part of the subject matter. But really we're talking about filing a notice of appeal because this part is critical. If you miss your notice of appeal, you lose everything else. You cannot continue on with the appeal. So I really want to hammer home in this video the importance of getting that notice of appeal filed, done right, done quickly. Okay, so now we're saying why appeal, because we've got some good options. We can improve our set of circumstances if the appeal is successful or if the superior court remands it back down for a new trial. Those are some good options. We also know that we just simply need to think about the notice of appeal right now and not the appellate memorandum and all of that complicated legal stuff. We just want to talk about the notice of appeal. But what are some bases for appealing a case? What is the basis? Why would people appeal it? Here's a list of just a couple. In reality, there are hundreds or thousands of different justifications for appealing a case, but just a couple of these I want to point out. Number one, it would be lack of sufficient evidence. So this actually does happen in court where the court will present their evidence, the government will present their case, and they just don't have enough there, but the judge will find the defendant guilty anyways, or the jury will find the defendant guilty anyways, even though the evidence just doesn't meet the burden. The government just doesn't meet their burden. And if the appeals court can take a look at that and say, we're right, factually it's impossible that this person could have been convicted on the set of facts that we are reviewing here, and so they'll overturn that verdict. Just a quick other one. Now, I'm going to make an entire video on this, but so, for example, if there's some juror misconduct, so let's say that when the jury is in the jury box, when they're deliberating, and they're communicating or they're texting somebody who's outside of the jury panel, if they're calling their husband or their wife and they're saying, hey, this is what's going on, look this case up, what's your opinion on that? If let's say, for an example, that a juror has a wife or a husband who's in the medical profession and they want to ask them about the specifics surrounding some claims regarding a DUI stop or something like that. That would be inappropriate. That's taking facts outside of the trial. That's misconduct. That may be a basis for a new trial, for an appeal. You could appeal that and say this was a problem, ask the court to give you a new trial and remand that back down. So you can see there's a lot of different bases for appealing cases. This is just some that I could think of kind of off the top of my head. These are some good arguments that you can make moving forward, but you can see ineffective assistance of counsel, if there were illegal rulings, improper jury instructions, abuse of judicial discretion, and so on. There are many, many reasons why you could actually file an appeal. But how can we get the most value out of this video? I'm going to cover some kind of in-depth points about actually how to file a notice of appeal. But who is this for? Who is this not for? I want to make sure you can understand where this is useful and when this is not useful. So who is this for? So it's for people who lost their criminal misdemeanor case. We're only talking about misdemeanors in this video. Misdemeanors are different than felonies. In Arizona, there are two really kind of main categories of crimes, misdemeanors and felonies. Felony appeals have a different set of rules. So you're going to want to refer to a different video that we have on that for felony appeals. Today, we're talking about misdemeanor appeals. And today, just to keep things clear, we're only talking about cases that were lost at trial and not resolved in another way. So plea deals, diversion deals, anything like that, or any sort of evidentiary hearings where there was a final order that was ruled upon. We're not talking about that. Just to keep it simple, we're talking about you took your case to trial, you lost it, you were found guilty of a misdemeanor conviction, and now you want to appeal it. There are tons of those. Now, I forgot to cover this in a previous slide, but another reason to appeal a case is because in Arizona, many judges are in our justice court system are not even actual lawyers. They're not even licensed lawyers to practice law. So they couldn't represent somebody else in court, but they can sit on a bench and they can convict people of crimes. It's a huge problem. The reason why you want to consider appealing it is because these people are making rulings on these cases, even though they never went to law school, never took a bar exam, never became a licensed attorney. They're still ruling on criminal cases. It's kind of bizarre, but it's how we do things in Arizona, unfortunately, for now. So it's people who lost their criminal case. The other thing, it's people with recent guilty verdicts. Recent guilty verdicts. We're going to talk about timelines and how important it is to make sure you're within that timeline. Because if you fail to file your notice of appeal timely, you're going to forfeit your right to appeal, meaning you are out of options. You can no longer appeal it because the filing deadline was already passed. And finally, we want to talk about people who want to win their case. Winning your case. This is something that's pretty important to, I think, almost everybody who's going to be watching this. But when I talk about winning, we're talking about specifically investing resources, investing time, investing some financial expenditures. I'm going to talk about what appeals cost here in this video. And it's really for people who think that something went wrong in their case, something went wrong at trial. I'm going to talk a little bit more about that, but it's for people who want to win. So in other words, if you're in a position right now where you lost your case and you want to win, really the best way to do that is through an appeal. There are other mechanisms to sort of go in the back door and attack your case through post-conviction relief and all sorts of different other mechanisms. But if you were just convicted of a crime and you were convicted recently and you want to win, this video is for you. It's going to give you some actionable next step items that you can do. Now, who is this not for? Okay, who is this not for? So it's for people who pled guilty. If you pled guilty, you can't appeal a guilty plea. If you went in and signed a document and entered a contract with the court and said, I'm pleading guilty, you can't then turn around and appeal that. Now, if you have done that and something else goes wrong, as I mentioned, you can go through the post-conviction relief process. That's a whole separate entity. We're not covering that in this video. This video is also not for anybody who is just unhappy with the outcome. So we talk to a lot of people who, go to trial and they lose their case and they're very upset. They call us and they say this was inappropriate. I can't believe this happened, but they don't have anything to sort of tack onto. They don't have nothing to dig their teeth into. They don't know what went wrong or why something went wrong. They just have this, they're just mad that they lost their case. I understand that. I empathize with that. But just because you lost an appeal doesn't mean that you have a basis for an appeal. Something needs to have gone wrong. Now, you don't have to be a legal scholar to identify that, but something needed to have gone wrong. You could say the officer made something up on the stand, or your attorney didn't ask a question that you wanted them to ask, and you think it was critical to the case or something like that. Usually those questions, I've been in those situations. I very rarely ask questions that are recommended by our clients, but if you believe that that was something that was critical, let's say your attorney left out a major part of the case or a major part of your defense against your wishes, that may be a basis for an appeal. So you need to have something there, something a little bit more substantive than it's just not a good outcome. And then finally, this video is not for anybody looking for a pro bono or a free lawyer. Unfortunately, there's just not a lot of resources out there for free attorneys anyways. There's even less for appeals. So if you've got somebody who's kind of sitting in custody and you want to continue to appeal their case, I've met with many people who bring in just, boxes and bins of documents. I just don't have the time or the resources, nor does our team have the time or the resources to look through that. There are organizations that are set up for that are, nonprofits, that are charities, that are run on donations, and things like the Justice Project. Those are going to be your best resources if you're looking for something like that. In most of those situations, this is not going to apply to those types of cases. But if you are looking for a pro bono or a free lawyer, look at the Justice Project. Many different places, especially in Arizona, we have what's called the Foundation for Legal Services, and they may be able to provide you some very low-cost alternatives. So hopefully that's helpful. Now, before I explain how to file a notice of appeal, I want to tell you just a little bit more about who I am, just so you understand. Now, I am a licensed lawyer, licensed in Arizona in 2013, federal court 2014, California 2015, Supreme Court 2016. The founding partner of the R&R Law Group. We're here in Scottsdale, founded in 2014. We've got 7 criminal lawyers here at our firm. We've handled thousands of different criminal cases all over. I wrote a book, Beginning to Winning. It's available on Amazon and on our website. I'll tell you about that a little bit later. I host Watching the Watchers. It's a live show that we do on Facebook and YouTube, and I'm on the board of directors over at Eric's House. It's a nonprofit. So that's sort of my credentials, just so you know who I am and why I'm telling you is good. It's good information, but I of course encourage you to do your own due diligence, make sure that it is accurate, and you can check your local rules and all of that. But that's my background. That's who I am and where I came from and what I do. Now, all that being said, I am not your lawyer, and this is not my legal advice to you. I'm not telling you whether you should file an appeal or not. I'm not telling you whether that's a good idea or a bad idea. I have no idea. I don't know anything about your case. And so, of course, you can call our office if you want to have that conversation. But just by watching this video, I can't possibly give you any legal advice because I know nothing about you. So I'm not your lawyer. Always consult with a lawyer regardless of any sort of legal entanglement that you're in. It's just the best way to go. I hire lawyers all the time, even though I am a lawyer. I hire them very regularly. Okay, so now let's talk about the court system. So now we're getting into sort of the background, the meat and potatoes of the Arizona criminal court system. And it's important to know where we're at. So as I mentioned at the beginning of the video, we're only talking about misdemeanor cases. The reason being is because there's different sets of rules and there's different things you need to do depending on where you're at in the court system. So I want to provide some context and let's review where we're at. So when we look at the hierarchy of courts in Arizona, it looks something like this. At the very bottom, and you can see here my laser pointer, we have the city and the justice courts. These are at the very bottom. These are lower level misdemeanor courts. You can see here their misdemeanor criminal charges happen here. It's the lowest level criminal courts in Arizona. They handle class 1, 2, and class 3 misdemeanors. These are the different justice courts you see, like the there's a on 40th Street in Bell, there's a whole justice center there that has a bunch of different courts, like the Desert Ridge Justice Court. We have some in the West Valley. We've got some in the East Valley. They're all in Maricopa County. A lot of the other different counties have courts like Mayor Justice Court, Seligman Justice Court. We've got Pima County Consolidated Court. These are all justice courts, and they all handle misdemeanor offenses. And so when we're talking about appealing these types of cases, we're talking about these courts: Scottsdale City Court, Phoenix City Court, Mesa Municipal Court, Tucson City Court. These are all different low-level courts, and they all handle misdemeanor cases. So if you've been in a trial in one of these courts and you want to appeal this, we're going to go up to the next level, which is going to be the Superior Court. So the Superior Court is going to hear the appeals from the city and the justice courts. Now, ordinarily, let's say if you were charged with a felony, you would just skip these city and justice courts and you would just go right into the Superior Court. Superior Court is a little bit different. Superior Court has judges that are actually licensed lawyers. When we're talking about the city and the justice courts, city court judges are almost, I think without exception, they're all licensed. But the justice court judges are not necessarily licensed. A lot of these people just run for office. They never went to law school, never passed the bar, never done any legal work at all, except take a kind of a crash course in how it all works, and now they sit and judge people. So when they make mistakes in their cases, and it happens all the time because, as I said, they have no formal legal training, it then goes up to the Superior Court. It goes up to the Superior Court. Up in the Superior Court, they're gonna review the record. They are licensed lawyers with typically a lot more experience, and they're going to issue a ruling. They're going to send it back down to the city and the justice courts. Now, if you work your way up, you can see here we have an appellate court and we have a Supreme Court. We're really not talking about either one of these two different jurisdictions. If you are appealing a felony, it's going to be heard by the appellate court. If you're appealing something from an appeals court, it's going to go up to the Arizona Supreme Court. And so that's just how the jurisdictions work. Now, when all of this happens, one of the most important things to keep in mind when we're talking about appeals is the timeline, the appeals timeline. It's very critical, and so I want to spend some time on this. There are different parts to the appeal process. There's really kind of two main parts. It's actually filing the notice of appeal and then drafting the appellant memorandum. That's going to go up to the Superior Court. You want to break that up into two different parts. And so when we're talking about time requirements, here's what I want you to keep in mind. The first one is the most critical. You must file your notice of appeal within 14 days of the guilty verdict. So this is the first document that needs to be filed. If we lose cases and we want to appeal it, or our client wants to appeal it, we almost will always do it on that exact same day while we're still in the courtroom. We'll just stand there and say, hey, we just got a guilty verdict. That's too bad. We're not going to stop. We're going to keep fighting this thing. We're going to file our notice of appeal right there, turn it into the court so that it's on record. We're not waiting. The reason why it's so important is because if you miss that 14 days, if you file your notice of appeal 15 days later, the judge will just deny it. You lose, you forfeit your right to appeal. They want these cases to close and be final. So if you're 15 days out, you're out of luck. It's critically important. And that's why I actually titled the video, How to File a Notice of Appeal, because this is something that I think that you should do. Whether you want to file an appeal or not, this is a good thing to just put a stake in the ground. You can say, I'm going to file my notice of appeal, but I'm not actually going to appeal, or you don't have to make that decision yet. You can just file it and then do your investigation and then decide whether you want to continue forward with the appeal. But while you're investigating it, if you don't file the notice, you're going to lose, you're going to forfeit your right to appeal down the road. So you can't just wait 30 days and say, you know what, I think I am going to file it. It's too late at that point, unless you have filed your notice of appeal. It'll make more sense here in a minute. You also need to pay for the record within a certain period of time. So after you file the notice, you must make payment with the court for the record. And again, that's 14 days it's within 14 days after the notice of appeal was filed. So I'm going to show you what that looks like. These numbers can be a little bit confusing. And then finally, you have the appellate memorandum. So now you must file an appeal within 60 days from the notice of appeal deadline. So I know it's a lot of numbers. If you're not familiar with these things, it can be difficult to kind of wrap that together. So I just want to diagram it out for you so it becomes a little bit more clear. So what I've done is I have all of this broken down on a timeline. You can see right here on the far left, what we have here is day 0. So this is day 0. This is the day you're in court. You lose your case. They enter a guilty conviction. You're found guilty on this day. Well, now what? Now you've got this 14-day window to file the notice of appeal. It's one of the first things that we should be doing here. File the notice of appeal. That way we have additional time. After that happens, we're going to go over, we've got this 14-day deadline. We have another 14 days. So let's say we waited until the final day and we filed our notice of appeal on day 14. We then have another 14 days to pay for the record. So then we got to go actually pay for it. So whatever the trial court has, we got to go make payment for that. We're going to talk to the clerk about how to do that. I'm going to explain that here shortly. So you've got this 14 days. Then from the notice deadline, from the notice of appeal deadline, you have 60 days to file your appellant memorandum. So that's when you're drafting the actual argument. So you can see here as we break that down, you want to file the notice of appearance, the notice of appeal, so that you have your 14 days. Then it's going to give you another 60 days to think about it, to investigate it, to review the trial record, to talk to a lawyer, to talk to your family, to talk to your friends, to think about whether or not this is important. But the point is, if you don't file that notice of appeal, you don't get the opportunity to file the appellant memorandum. So it's important that you follow that timeline. Now, once that appellant memorandum is filed, then we can take it over and we're basically done at that point in time. Now it's going to sit here, and within the 60 days, the government, the prosecutor's office, has the opportunity to file a memorandum themselves. So they have 30 days then to go in and file that. And once that 30 days has expired, the court is basically going to sit on it for 60 days and then transfer it over to the superior court. So they're going to just kind of hang on to it for about 2 months, and then they're going to transfer it over. And at that point, you're going to get a superior court case number that identifies it in the superior court, and then you're going to get further action, further notice from the superior court. They're going to let us know if you want any more documents or any more communication, or they're going to schedule oral arguments or whatever they decide to do with it. They're going to take it from there. But you can see here, I mean, even just with this little process, we're talking almost 6 months here of kind of waiting and researching and filing the memorandum and doing our research and making our arguments. So it is a little bit of a delay. There's a lot of kind of waiting time after you file the notice of appeal, but you got to file that notice of appeal. It's pretty important. So I'm being presumptuous. I'm presuming that that is what you want to do because of some of the reasons that I explained. It just kind of puts a stake in the ground that you can come back to. And so if we've made that decision, now let's talk about actually getting that document filed. It's not super complicated. It's a pretty simple document. Here's what it looks like. So this is the notice of appeal. and it is about 2 pages. It's exactly 2 pages. You can see it right there. It's very easy to fill out. You really don't need a lawyer for this. If you want, we can help you with this, of course, along with everything else that I've already spoken about. But you really don't need a lawyer. You can just download a copy of this document. I'm going to make it available. It's going to be available in Microsoft Word. If you have a printer or a PDF printer, then you can just make the adjustments in the actual document and file it yourself. So you don't actually need to hire an attorney. You can file the notice of appeal, tell the court you're appealing, and then call our office and we can discuss some strategies and what we think is winnable or not. And so you can see that it's very basic. Now what I want to do is run you through the 4 or 5 different main parts of this actual document. I'm going to give you a copy of the document, and this way you'll know how to use it. So the first part of it is going to be the heading. Okay, this is pretty important. This goes on at the very top. This is kind of the standard process for most motions and most filings, but you're going to want to fill out your name, address, phone number, and email address. All this is very important. When our firm does this, we put all of our firm stuff on here. We put the name of the court here. So you say that in the Scottsdale City Court, in and for the County of Maricopa in the state of Arizona. You're going to put your case number here. This is the case number of the case that you just lost. It's important that it says defendant's notice of appeal. It's going to have your name. Okay, this is the heading. It's very, very basic. I just explained it. You don't need a lawyer to fill that out. Pretty simple stuff. The next part of it that is just a little bit further down is really the body. It's really the kind of the nuts and bolts of the motion. This is where we're telling the court what we're appealing and why. So the undersigned appeals from the final order or the final judgment in the above case as follows. So all you're doing right here, right after in the highlighted hypothetical, in the parentheses, explain what you're appealing. So if you're appealing, if you just lost a DUI case, you're just going to say convicted of 2 counts of DUI on this particular day on January 1st, 2020, and that's what you want to appeal. You're just defining what that is, because you may not want to appeal all the charges. Maybe it's just one charge. Let's say, for example, you got a DUI and you got a speeding ticket. Well, you lost the speeding ticket. You don't really care about appealing that, but you do want to appeal the DUI charge. So we're going to say we want to appeal that, and here's why. The appellant also understands, and they've read the notice of the right to appeal, which you should receive after you get a guilty verdict. You should have a copy of that in your hand, and you know that you have other things to do. So you have to pay for a copy of the record. You have to get a certified transcript or potentially get a certified transcript. There's just a lot of other things that you need to do. And so this language that you see in this slide, number 1, 2, 3, and 4, you want to make sure that you read those and understand them, and you're basically telling the court, yes, I know that I'm required to do these things, and if I don't do them, there's going to be a penalty that's going to result in the dismissal of my case. So just read through those and make sure you understand how those work. The court wants to make sure you know what you're doing, and if you fail to act, it's going to result in the dismissal of your appeal. And all this language, it comes directly from the rule, comes directly from the statutes. It's verbatim what you need. So that's the type of language that you can just put right into your own motion if you choose to write one. The other part that we want to put in there, because the rules require this, is your address. We want to make sure that the court has your address. This is all language that is included in the motion. Put your address in there. Put it in there, whether you've got an attorney or not. If we file these, we're putting your address in there. The court wants to be sure that you're notified, and you're also when you sign this document, you're also saying the court will be notified in writing of any change of address. They want to be very clear here. You need to have proper notice. So if the court is moving to dismiss your appeal, or they're trying to do something to throw this thing out, they need to notify you. You want to be sure that you're receiving it. So it's important that of course, your attorney is on top of that, but also that you have your address on file with the court. Now, any motion that you're going to be submitting, it needs to be submitted on your behalf. You can't do this for anybody else if you are not a lawyer. If you're a lawyer and you're licensed in that particular jurisdiction or in Arizona, then you can file this for somebody else. We can file it for you. But if you want to appeal on somebody else's behalf, unless you have that law license, you cannot do that. But you do need to sign the document. So respectfully submitted this 25th day of September 2020 or whatever it is, your signature and your name. So print a hard copy of that, sign it with some ink, and mail that off. Now, the important thing that you also want to consider is what's called the certificate of service. So this is what makes up the second page. It looks like a lot of stuff. It's really not. This is what the certificate of service page looks like. And basically all you're doing is you're saying what you did with this document. You need to tell them what you're doing, and then you need to do it. So you're going to say the original of the foregoing was sent via mail on this day of this month in 2020. And then all of this is the court's address. So the clerk of the court, the clerk of, the Scottsdale City Court, that address, fax number, email. You can find almost all of this stuff right on the court's website, or call the court itself and just tell them, hey, I need to file a motion. How do I do that? What's the best way for me to do that? I need to file a notice of appeal, and they'll tell you what to put right in there. I also like to include a copy of everything over to the prosecutor's office. So we send them a courtesy copy just so they know, hey, we're appealing this. This is what it looks like. You're going to get a copy of this in the mail. The court is also probably going to send them a copy, depending on the court and how they do things. They're going to send a copy over to the prosecutor's office. So the prosecutor is going to get it anyways, but we just send it just as courtesy to say, look, we're filing an appeal on this thing. At some point, we may file that appellant memorandum, and you're going to be having to file a response to that, and be on notice. Okay, be aware that this is coming down the pike. It's kind of a good, courteous way to do things. It's also important when we file these things. I talked about timelines and the importance of timing. So it's important that we have a good record of that. When are we filing things? And we want to make sure that the court accepted it. So whenever we file motions, we get what are called conformed copies back. So we go into the court, or we have the court stamp and mail us back a copy. And here's what it looks like. It's called a conformed copy, but basically all we're looking for is the seal of the court. We want the court to stamp it. So you can see here, when we filed this on March 5th, 2020, they just stamped this document and they just mailed it right back to us. So Mayor in Arizona is a court. It's sort of on the I-17 in between Phoenix and Sedona. And when you drive up there, it's just south of Prescott. They want everything done by paper. They want everything printed and paper and everything like that. So we print off one extra copy. We mail it to them. We put a self-return envelope, they stamp it, and they mail it back to us. Now we have this for our records. So we know that they accepted this document. They got a copy of this thing because we filed it. We have this as hard proof that they got it in their file. So if they were to ever claim that we didn't receive this, we have proof that no, you did, because you stamped it and you signed it back. So you may want to do that. And if you're going to be going down to court and filing these things in person, that's a good practice to get into. Now, keep records of everything, all your emails, all your submissions, all your phone calls, all of that stuff, because if this comes back and they're claiming that there was a timing problem, you want to be able to refute that. And so, as I mentioned, we're going to give you a copy of that free notice of appeal form. Just look at the description. It should be right below the like and the subscribe button. Just go down there, click that link. It's going to take you right over to the form, and you'll be able to just fill it out sort of like I showed you to. And so, actually, let's just take a quick pause. Let me show you the actual document. So if we blow this up on my screen here, this is the actual document. You can see here, this is what it looks like. And so when you are going through it, this is going to be what you're working on. So just go in here, just adjust these different highlighted portions, fill out what you need to fill out, remove the highlights, print it, and send it off. That's the entire document, and that should give you a good starting point. Now, if the court tells you to do something differently, keep in mind, this is just a general form. There are 180 different courts in Arizona. Some of them do things differently. Some of them want things done differently. So if the court tells you to do something else, do it. Okay, you're not being represented by an attorney. That happens to us all the time. The court clerk calls back and says, Judge so-and-so wanted it done this way. Do it this way. Put a period here. Do this, that. Okay, fine. We just fix it and send it back. So get in touch with the court clerk. Get in touch with the people who you're submitting this document to make sure that you're doing it appropriately. But as I said, this document comes directly from the rules. This is the language right from the rules of appeals for misdemeanor cases. So that should be all that you need. Should be a good starting point for you. Now, we're talking about what to do next. So you filed your notice of appeal. You've done it within that 14-day window. So you're going to be good to go, but you're not done yet. There are still other things that you need to do. Now, if you wanted to speak with an attorney or speak with our office or hire an attorney to handle this all for you, we're happy to have that conversation. We offer free case evaluations. We can have you come in or do it over the phone, do it over Zoom, and talk you through it and explain what the next process looks like. A lot of this is stuff that we do for you, but if you are just looking for kind of the quick and dirty next steps, here's what it looks like. You're going to want to make sure that you pay for a copy of the record. So as I said, when we backed up there, you remember in the previous slides that there was that green portion. There's also a deadline to pay for the record. So you can file your notice of appeal. You got to come back quickly within that 14 days and actually pay for the record. So as I said, communicate with your court clerk about this. Find how much it costs for them specifically. Costs vary slightly, but generally it's around $325. It's not super expensive. Depending on the trial, depending on the length of the trial, you may have some additional costs depending on the clerk, depending on whatever they want. But you want to make sure you pay for that. Okay, that's important. Get that done quickly. Number 2 is to then go ahead and obtain copies of all the trial records, and you want to research all of the legal issues that are in there. So depending on where your trial was held, there may have been a court reporter there. There may have been somebody in the courtroom who was actually typing everything up, and you can get a copy of those records. Probably not if this was a misdemeanor. Most misdemeanor cases don't have that going on in Arizona. Most of them are just recorded by audio or video. So if you get a copy of the record, you may want to have that transcribed. You may want to take that audio video and actually, order transcripts to be completed. There are some certified transcription services in Arizona, people who are actually contracted with the courts to do these types of things. They have to listen to the whole trial, and they have to write everything down and timestamp it and certify that they did it correctly according to the rules. And so that can be pretty expensive. When I was talking about expect some costs and expect some time and expect some resources, this is where it goes. A lot of it is expensive because basically you're hiring somebody to listen to the whole trial that already took place. So not only did you have to pay for, the jurors and the judges and the bailiff and your attorney and the prosecutor and everybody involved, but now somebody has to go back through that and listen to it again and reanalyze it again and review everything that took place previously. So if you're appealing a case and you had an attorney and they did a good job, they're probably filing motions and making arguments, and there's a lot of material and police reports and negotiations taking place and all sorts of stuff. So it can be a very long process, which is why I'm saying you want to just start thinking about it now, obtaining copies of all of those different documents, all of those different things. Start gathering up everything you can think of related to the case, because you're going to need that for the final step, which of course is preparing, drafting, and submitting your appellant memorandum. So this is the actual appeal. This is the final document that you send over to this is your memo. This is the big deal. This is the part in the case where you're making all of your final arguments and sending that off to the court for their review. And so you want to listen to everything, you want to record everything, you want to research everything, and you want to draft up your document. The actual process of drafting the appellant memorandum is outside the scope of this video. There's a lot that goes into it. You really should have an attorney help you with that because of the complexities of it. What an attorney is doing is listening for problems that took place in the preceding trial, and that's a skill set that is very difficult to learn in a YouTube video. We've been studying this for years and years and years and practices every day. And so that's where our expertise comes into play. But you can't file an appellant memorandum if you haven't filed a notice of appeal. So if you're interested in filing a notice of appeal, that's something that you absolutely can do. But generally speaking, leave the appellant memorandum to yourself. Now, that's not to say that you can't do your research and go to a law library or purchase Westlaw or LexisNexis or any one of the free cases that fast case, any tools that we use, you can do that. But just keep in mind, there's a lot that goes into an appellant memorandum. So it can be a little bit much to bite off if you're not familiar with the process. So we've covered a lot. We've been talking for 38 minutes on how to file a notice of appeal. And I want to just leave you with a couple takeaways. So a couple things that are important as a result of everything we've discussed thus far. Keep in mind, filing a notice of appeal is not the final appeal. It is not the final appeal. You can file a notice of appeal and not actually appeal the case, but you're just preserving your right. You're preserving your right to come back and file that appeal at a later date. It's perfectly acceptable to file a notice of appeal, investigate, and then not appeal it at all. It just simply provides us the opportunity for more time to make that decision. It's just something to think about. If we've lost our case, let's just file the notice. Then we can decide whether we want to leave it alone or move forward. It's also very important to understand that there are critical timing requirements that must be met. If you do not meet the timing requirements, you lose your right to appeal. If there's one thing you're going to take away from this video, timing is strict. Failure to file timely may result in your loss of a right to appeal. And the courts are pretty strict about this. They just don't bend over for you. Some courts are very strict about it, and they will calculate it. There are additional rules on calculations that I'm not going to get into here, but some courts are very aggressive with this, as they should be. It's the rule. So lastly, do not delay your research and your preparation. So as I mentioned previously, courts are strict about the deadlines. They are not regularly extended. And so as you're going through this process, keep copies of everything that you're doing, log everything, stay organized, know where things are. Many times when people want us to appeal cases and they bring their stuff into our office, it's in a bin, like a crate like this with just documents everywhere. And we don't even know where to start. We don't even know where to look because it's so much. So the bulk of our time is spent sort of organizing things and saying this is relevant, not relevant, relevant, not relevant. And we just focus on, we have to decipher a lot. But if you could keep it organized, if you could come in and have everything more or less organized or labeled at least, that makes our job a lot easier. And if you're going to be doing this on your own, it's going to make your job a lot easier too. So do not delay in any of your research and your preparation. Now, if this sounds like something you can jump into and something that is easy for you to run with, great. I'm excited for you. But if you do want to stay in touch, let me show you a couple different ways you can do that. So first and foremost, I've got a book. It's called Beginning to Winning. It has my 9-step framework for finding success in any criminal case. It's got 3 key principles for making the best decisions in criminal law. And it's got a lot of forms, motions, and charts and real-life examples that you can use in your case. Now, this is really not applicable for an appeal. If you have already lost your case, this book may have been helpful preceding that. But now that you have lost your case, this book does not cover much about appeals. But if you're watching this because you're kind of in the middle of it and you're wondering, well, maybe I want to reserve my appeal rights and I want to start thinking about that because I don't like my chances. I don't like my attorney. I don't like the court that I'm in. I'm in one of these justice courts in Arizona where they're not even a licensed lawyer. So now you're thinking strategically about your appeals. This may be a good book for you. This may be something that can help you because it sounds like you're probably still in the thick of your case before you actually get to a trial. So check that out. Beginning to Winning. It's available on Amazon and beginningtowinning.com. I also want to tell you about a fun little project that we've got going on. It's called Watching the Watchers. It's a live show that I do on Wednesdays currently, and that's taking place live on YouTube and on Facebook. If you want to connect on Facebook, join our group, the Watching the Watchers Facebook group. You can just go to Facebook and just Google, or just don't go to Facebook and Google. Just go to Facebook and then search Watching the Watchers. It's this group, and every week we do live shows, and we've got a pretty cool community that's growing there. Weekly live streams, criminal law, legal news. We've been covering a lot about the coronavirus lately. Interviews. We are doing interviews with other people, former law officers, former detectives, people who've kind of switched over to the defense side. We've got people running for office. We had on a county attorney candidate running for an election recently. So really cool people who are being interviewed. And then, of course, we have everybody's favorite part of the show, which is the Bad Popo segment. It's the Bad Popo. And you can see I've got a lot of Bad Popo that I've covered previously. These are all tacked up on a wall in my office, but we cover them. New Bad Popo. These are all different officers who've committed crimes, different prosecutors who have engaged in some sort of misconduct, and we call them out. We make sure that they are known. Now, if you want to hire us, of course, for an appeal, if you want to hire us for any criminal case, if you want to talk to our team about that, please do so. I'm with the R&R Law Group if you haven't gathered that already. All Arizona criminal cases, we offer free case evaluations. Our website's rrlawaz.com, 480-787-0394. And yes, we also do appeals. So don't feel like you have to go through this thing alone. If you're watching it and you're still well within the 14-day window, we'll file that notice of appeal for you. You don't need to do it on your own. You're welcome to if you want. The link to the document is going to be in the description. Again, right beside that subscribe button, which I'm encouraging you to do. And we can work through it. We can talk about what you need to do, whether you need to do it or not. Help you make that decision according to a lot of the frameworks and prior experience that we have. So that's how that works. If you don't want to do any of that stuff, if you just want to connect with me, you can find our office on Facebook at Your Criminal Defense Attorney. You can find me on Twitter at Robert Gruler ESQ, or you can just subscribe on YouTube. If you're not here already, head on over to our YouTube channel. That's at rrlaw.tv. Hit subscribe. All of our content goes there. We spend a lot of time on our YouTube channel. We want to provide as much value to you as we can. At our office, we say that we really are passionate about helping good people charged with crimes get through the criminal justice system, get their life back on track. We know that most people are very good people. They just screwed up once. They one bad night, one bad argument, one bad fight, and that should not shackle them for the rest of their lives. So if the appeal process is something that you want to talk through, give our office a call. You saw the number. You're going to have all the contact information in the forms below. In the meantime, I want to thank you for watching. Please subscribe so you can get more of our content on a regular basis. We'd love to have you back. Until then, thanks for watching.